We often talk about our fundamental rights, but when the rubber meets the road, say, you're facing criminal charges, what safeguards are truly in place? One of the biggest bulwarks against injustice is the right to legal counsel.
It really is. It's a cornerstone of fairness, isn't it? Imagine trying to navigate the complex legal system. I mean, understand procedures, build a defense, all while your freedom basically hangs in the balance.
Yeah, absolutely.
That's why we're taking a deep dive today into, well, the pivotal case of Gideon v. Wainwright.
Gideon v. Wainwright, yeah, a name that really resonates throughout American legal history. And while it was a huge moment, it wasn't, isolated. It laid the groundwork.
Exactly, for subsequent Supreme Court decisions that have sort of reinforced and broadened this fundamental right.
And that's what we want to explore, how the core principles from Gideon have echoed through later, seemingly different legal challenges.
Right. So to do this, we'll be digging into the source material itself, excerpts from the Supreme Court's opinions, Gideon v. Wainwright, obviously, but also cases like Alabama v. Shelton, Miranda v. Arizona, and Mitchell v. Wisconsin.
Okay, so our mission today is to understand that foundational principle in Gideon.
Yeah.
The right to counsel for those who can't afford it when facing serious charges, and then trace how these later cases, even with their unique facts, arrived at similar kinds of conclusions that ultimately strengthen that right to counsel in different critical stages of the legal process.
Sounds like a plan.
Okay, let's unpack this, starting with the case that really started it all,
Yeah.
Gideon v. Wainwright.
Yeah, the story of Gideon itself is pretty compelling. Clarence Earl Gideon was accused of a felony in Florida, breaking and entering a pool hall, actually, with the intent to commit a misdemeanor.
Okay.
Now, he was too poor to hire a lawyer, so he asked the court, appoint one for me.
Makes sense.
But at that time, Florida law only provided state-funded attorneys in capital cases,
Yeah.
cases where the death penalty was possible.
Ah, okay, so not for his charge.
Right. His request was denied. He had to represent himself.
Wow. Think about that for a moment, facing serious felony charges with zero legal expertise, no one guiding you through the courtroom complexities.
It's hard to imagine. And, well, unsurprisingly, Gideon was convicted, sentenced to 5 years in prison.
But here's where the story takes that fascinating turn. While he's in prison, Gideon apparently dedicated himself to studying law.
He did, and his legal studies convinced him, that his constitutional rights had been violated.
So he takes action.
Yes, he filed what's called a habeas corpus petition. Basically, it's a legal challenge saying, hey, my imprisonment is unlawful because I was denied a lawyer.
Okay.
The Florida Supreme Court didn't agree with him, but Gideon, still locked up, hand-wrote a petition asking the U.S. Supreme Court to hear his case.
Just wrote it out by hand.
Yep, and remarkably, they agreed to take the case.
It's incredible. Just an amazing testament to his conviction.
Yeah.
So what was the fundamental legal question the Supreme Court had to wrestle with in Gideon?
Well, the central issue is this. Does the Sixth Amendment's guarantee of the right to counsel, which applies in federal criminal cases, should that also apply to felony defendants in state courts?
Ah, the state versus federal distinction. That's key.
It is, because remember, the Bill of Rights initially was seen as primarily limiting the power of the federal government, not the states.
Right. So to really get the significance of Gideon, we need to look at some of the legal groundwork, the precedents leading up to it. What were some key cases the court considered?
Yeah, there were several crucial stepping stones. The Sixth Amendment itself, obviously, that's the starting point. And the court had already said back in Johnson v. Zerks that the federal government had to provide lawyers to indigent defendants in federal criminal cases where jail time was possible.
Okay, so established for federal cases.
Right. Then you have the 14th Amendment,
Mm-hmm.
comes after the Civil War, and it includes the Due Process Clause. It says states can't deprive anyone of life, liberty, or property without due process of law.
And that's the bridge.
That's the bridge. That clause became the mechanism, the way the court started applying many Bill of Rights protections to the states, too. It ensures those promises apply to state actions, not just federal ones.
Got it. Okay, so the 14th Amendment is crucial here. Any specific cases using it before Gideon?
Absolutely. Powell v. Alabama in 1932 was huge. It involved the Scottsboro Boys, 9 young black men accused of a capital crime in Alabama, rushed through the system, really inadequate legal help.
Right, I remember that case.
The Supreme Court recognized, look, in capital cases at the state level, the right to counsel is a fundamental right, protected by that 14th Amendment Due Process Clause.
Okay, so definitely required when someone's life is on the line. But Gideon's case wasn't capital. So what about other felonies?
Then That brings us to Betts v. Brady, 1942, just a decade after Powell. And here, the court ruled differently.
How so?
They said the 14th Amendment did not automatically require states to provide counsel in non-capital felony cases.
Really? So what was the rule then?
They adopted a sort of special circumstances rule. Courts had to look at each case individually. Did the lack of an attorney in this specific case result in a fundamentally unfair trial? It wasn't an automatic right.
So Betts v. Brady created this kind of two-tiered system. Capital cases, you get a lawyer. Other felonies, maybe not, depending on the circumstances.
Exactly. And that is the precedent that Gideon was directly challenging.
So Gideon's argument was?
His argument was simple but powerful. A layperson, someone without legal training, is just hopelessly outmatched against the state in a criminal trial. He argued the right to a lawyer in any felony case is so essential to a fair trial that it must apply to state courts through the 14th Amendment. Full stop.
Makes intuitive sense. And the Supreme Court, they agreed unanimously, wasn't it?
Yes, in 1963, a truly landmark decision. The court sided completely with Gideon, explicitly overturning Betts v. Brady. Justice Black, writing for the court, stated very clearly, "The right to counsel in felony cases is fundamental. It's essential for a fair trial, and therefore it applies to the states through the 14th Amendment's Due Process Clause. No more case-by-case analysis for felonies."
What a monumental shift in American law. The impact of Gideon must have been, well, immediate and massive.
Oh, it was profound. Gideon basically erased the Betts precedent. It established a clear nationwide right. If you're facing felony charges and you can't afford a lawyer, the state has to provide one.
That just dramatically reshaped criminal justice, didn't it?
Completely. It made the system significantly fairer for indigent defendants facing serious charges. It's truly, as you said, a cornerstone of our justice system today, ensures that basic level of fairness.
Okay, so Gideon lays this crucial foundation. Right to counsel in felony cases. Now, let's pivot to Alabama v. Shelton. Here, the facts are different. Shelton was charged with a misdemeanor. Can you set the scene for us on that one?
Sure. LaReed Shelton was charged with third-degree assault. That's a misdemeanor in Alabama. But importantly, the charge carried the possibility of both a fine and jail time.
Okay, potential jail time is key.
Right. Like Gideon, Shelton couldn't afford a lawyer, requested one, but the court denied it, reasoning it was just a misdemeanor.
Even with possible jail time?
Even with possible jail time. So he represented himself, was convicted, and got a 30-day jail sentence.
Okay, so he was sentenced to jail.
Yes, but, and this is the crucial part, the sentence was immediately suspended. He was placed on probation for 2 years instead.
Ah, suspended. Meaning he wouldn't go to jail unless...
Unless he violated his probation. If he messed up probation, then he'd have to serve that 30-day jail term.
Okay, so he wasn't immediately locked up, but the threat of losing his liberty was definitely real, hanging over him. So what was the legal question in Shelton?
The core issue was, does that Sixth Amendment right to appointed counsel, the Gideon right essentially, extend to a misdemeanor case where you get a suspended jail sentence, a sentence that could lead to actual imprisonment later?
So it's building on Gideon's idea about liberty being paramount, right? Even though it's just a misdemeanor, the potential for jail is there.
Exactly. Does that potential trigger the right to counsel? How does this connect back to that fundamental principle we saw in Gideon, ensuring a fair trial when liberty is at stake?
Yeah. So what precedents did the court look at here?
Well, they looked back at their prior rulings. Argersinger v. Hamlin was key. That case established that the right to counsel applies in any criminal case, felony or misdemeanor, if there's a possibility of imprisonment, actual imprisonment.
Okay, Argersinger says possibility of jail means you need a lawyer.
Right. The reasoning being going to jail, even for a short time, is a significant deprivation of liberty. You need a lawyer for a fair shot.
But wasn't there another case, Scott v. Illinois, that seemed to draw a line differently?
Yes, good point. Scott v. Illinois held that if the defendant is ultimately just fined, not jailed, even if jail was a possible punishment for the crime, then there was no constitutional right to appointed counsel.
Huh. So Scott focused on the actual outcome, not the potential. If you only got fined, no lawyer needed, even if you could have gone to jail.
That's basically it. The actual imposition of a jail sentence was the trigger in Scott for non-felony cases.
So back to Shelton. His sentence was suspended, not immediately imposed. How did the court square this with Argersinger, possibility matters, and Scott, actual jail time matters?
Well, the Supreme Court, in a 5-4 decision, sided with Shelton. Justice Ginsburg wrote the majority opinion.
And the reasoning.
They emphasized that a suspended sentence still carries the real threat of imprisonment. If Shelton violated probation, that 30-day sentence wasn't just hypothetical, it became real. So the court reasoned that it's that potential for imprisonment, activated by the suspended sentence, that triggers the constitutional right to counsel. You need the lawyer back at the trial stage where guilt is determined, because that conviction is the necessary basis for any future imprisonment if probation gets revoked.
Ah, so the fairness of the initial conviction matters, because it could lead to jail later. The suspended sentence itself is enough of a liberty threat.
Exactly. The court basically said, look, a suspended sentence that might land you in jail is serious enough. It's a significant enough penalty that you need the safeguard of counsel at the trial where that possibility is first established. As the opinion put it, if the crime could lead to a jail term, the Constitution requires a lawyer.
Okay, that makes sense. So Shelton really extends that core Gideon principle right to counsel when liberty is at stake to situations where that deprivation is potential, hanging over you via a suspended sentence.
Precisely. It reinforces that fundamental concern about fairness when potential imprisonment is on the line.
All right, now let's shift focus again. Miranda v. Arizona. So we've seen the right to counsel in the courtroom, felonies in Gideon, potential jail and misdemeanors in Shelton. But what about before trial, that crucial pretrial stage?
Right, and that's where Miranda v. Arizona comes in, focusing squarely on custodial interrogation, police questioning someone who's in custody.
Can you remind us of the facts in Miranda?
Sure. Ernesto Miranda was arrested for kidnapping and rape. Police interrogated him for 2 hours while he was in custody. He confessed.
And the issue was?
Crucially, he was never told he had the right to remain silent or that he had the right to have a lawyer present during the questioning. So his confession was used against him at trial, and he was convicted, and his case was consolidated with 3 others involving similar situations.
Okay, this obviously brings up the Fifth Amendment right against self-incrimination. But how does the right to counsel, which was so central to Gideon and Shelton, factor into this pretrial police station scenario?
Well, the court recognized that custodial interrogation, being questioned by police when you're not free to leave, is inherently coercive. It creates the significant risk that people will incriminate themselves, maybe without even meaning to, or without fully understanding their rights.
Right, the pressure of the situation.
Exactly. So the presence of a lawyer during questioning acts as a critical safeguard against that pressure. It connects directly back to Gideon by ensuring people are aware of their constitutional rights, including the right to counsel, and can effectively use those rights when they're facing the power of the state in that interrogation room.
Because if you don't know you have a right to a lawyer there, you can't ask for one.
Precisely. You can't exercise a right you don't know you have.
Was there a case before Miranda that sort of touched on this intersection? I think Escobedo v. Illinois.
Yes, Escobedo in 1964 was an important precursor. In that case, Danny Escobedo was arrested, and police repeatedly ignored his requests to speak to his lawyer during interrogation.
He actually asked for his lawyer.
He did. And the court found his Sixth Amendment rights were violated. They also noted he should have been reminded of his right to remain silent. Escobedo basically established a right to consult with your lawyer once you're in custody, if you ask.
Okay, so Escobedo relied on the suspect asking. How did Miranda build on that? It went further, didn't it?
It went much further. Instead of waiting for the suspect to ask for a lawyer, Miranda mandated that police must proactively inform suspects of their rights before questioning begins.
Ah, the warnings.
Exactly. The now famous Miranda warnings. Police have to tell suspects, you have the right to remain silent. Anything you say can be used against you. You have the right to an attorney present during questioning. And crucially, echoing Gideon, if you cannot afford an attorney, one will be appointed for you.
So it's not just about the right existing, but about making sure the person knows about it, especially the right to counsel, even if they can't afford it.
That's the core of it. The reasoning is all about ensuring that if someone does decide to waive these rights and talk to the police, that waiver is truly knowing, intelligent, and voluntary.
Because without being informed, how can you make a genuinely voluntary choice under that kind of pressure?
That's exactly the court's rationale. The psychological pressure of being in custody, being questioned, it's immense.
Yeah.
Without clear information about their rights, suspects might feel compelled to talk. Having a lawyer there, or at least knowing you can have one, helps level the playing field. It protects that Fifth Amendment right against self-incrimination.
So it's about ensuring fairness even before trial, much like Gideon ensures fairness in the courtroom.
Yes. While Miranda focuses on the interrogation room, not the courtroom, it shares that fundamental concern with Gideon and Shelton. protecting individuals, ensuring they have access to legal counsel or at least knowledge of that right when their liberty is potentially at risk, especially when they might not know how to assert that right themselves.
Okay, so Gideon, Shelton, Miranda. They all seem clearly focused on the right to counsel at different stages where liberty is threatened. Now, the final case we're looking at, Mitchell v. Wisconsin, this one feels a bit different. It's primarily Fourth Amendment search and seizure, right?
It is, yes. Primarily Fourth Amendment. But it raises interesting questions that I think implicitly connect back to these broader themes of individual rights and the practicalities of enforcing laws when someone literally cannot exercise their rights.
Okay, tell us about Mitchell.
Gerald Mitchell was arrested for drunk driving in Wisconsin. He did poorly on a field breath test, but he was apparently so intoxicated that other field sobriety tests weren't safe to conduct.
Scarily impaired.
Very. Police took him to the station, but then he became unconscious. He was taken to the hospital. While he was unconscious, police directed hospital staff to draw his blood without a warrant.
Without a warrant, how?
Under Wisconsin's implied consent law. The law basically presumed that by driving on Wisconsin roads, you consent to a blood test. And if you're unconscious, you haven't withdrawn that consent.
And that blood test showed.
His blood alcohol content was significantly over the legal limit, and that evidence was used to convict him.
So the core legal issue was that warrantless blood draw from an unconscious driver lawful under the Fourth Amendment's protection against unreasonable searches and seizures?
Exactly. That's the Fourth Amendment question.
So where does the principle of ensuring fair process, the Gideon idea, fit into this? The person is totally incapacitated.
Well, it's not a direct Sixth Amendment right to counsel claim, obviously. But the scenario an unconscious individual starkly highlights a situation where a suspect is physically incapable of exercising any rights. They can't consent or refuse a search. They can't invoke their right to remain silent. And crucially for our discussion, they absolutely cannot request legal counsel to advise them.
Right. They're completely vulnerable.
Completely. So in that context, the legal framework governing searches, especially exceptions to the warrant requirement, becomes incredibly important. It's about how the law protects rights, even when the individual can assert them. Mitchell forces us to think about how legal rules operate when the capacity for rights assertion, including consulting counsel, is absent.
Okay, so the Fourth Amendment usually requires a warrant for a search, but there are exceptions, like consent or exigent circumstances, emergencies, basically. How did those play out here?
Wisconsin initially leaned heavily on the implied consent argument. Mitchell consented by driving, and unconsciousness isn't withdrawing consent.
Okay.
The Supreme Court, though, ended up focusing more on the exigent circumstances exception. They talked about precedents like Missouri v. McNeely. That case said the natural dissipation of alcohol in blood doesn't automatically create an exigency in every DUI case. It needs a case-by-case look.
Right. No automatic emergency just because it's alcohol.
And they also mentioned Birchfield v. North Dakota, which distinguished between breath tests and blood tests. Birchfield said states could generally require breath tests under implied consent laws as a search incident to arrest, but blood tests are more intrusive, maybe needing a warrant for conscious drivers.
Okay, so with all that background, what did the Supreme Court decide in Mitchell?
It was a plurality decision, meaning not a majority of the full court agreed on the exact reasoning, but enough agreed on the outcome.
And the outcome was?
They held that when police have probable cause to believe a driver is drunk and the driver becomes unconscious, a warrantless blood draw is generally permissible under the exigent circumstances exception.
Why exigent circumstances here?
Justice Alito, writing for the plurality, reasoned that the need to get timely blood alcohol evidence because alcohol dissipates combined with the driver's unconscious state, which itself requires police attention and often medical care, creates an emergency situation, an exigency.
And a breath test wasn't an option.
Right, because he was unconscious. So the blood draw was seen as justified by these combined factors, creating an exigent circumstance.
It's interesting, though, the dissenting justices, particularly Justice Sotomayor, raised concerns. What was their main point?
A key point in the dissent was procedural. They argued the state hadn't really argued exigent circumstances properly in the lower courts. The Supreme Court was deciding the case on grounds that weren't fully explored below.
Oh.
They also stressed the importance of that case-by-case analysis for exigent circumstances required by McNeely. They questioned whether getting a warrant in this specific situation would have truly risked losing the evidence, especially with modern electronic warrant procedures.
So Mitchell isn't directly about the right to counsel like the others, But the situation it presents, someone completely unable to exercise any rights because they're unconscious. It really underscores why we need clear legal rules to protect fundamental rights in all sorts of weird circumstances.
Yeah.
Even the ability to just ask for a lawyer is gone.
Exactly. It highlights the vulnerability of individuals within the system, even when they're passive participants. So, okay, let's step back. Look across these 4 cases. Gideon, Shelton, Miranda, Mitchell. What are the common threads? How do they connect, despite having such different facts?
Well, it's striking how the deep concern for individual liberty runs through them, isn't it? Gideon is about the right to counsel when facing serious prison time, a felony.
Right. Loss of liberty.
Shelton extends that. It's about the potential loss of liberty, even from a misdemeanor, through that suspended sentence.
Still liberty at stake.
Miranda then takes it earlier,
Mhm.
into the police station. It recognizes you need to know about your right to counsel when your liberty is threatened during that coercive interrogation.
Yep, critical pretrial stage. And crucially, Miranda requires informing suspects about the right to appointed counsel if they can't afford one. That's a direct echo of Gideon's core concern for the indigent.
Absolutely. And even Mitchell, although it's Fourth Amendment, the whole context is someone losing control, unable to assert any rights due to unconsciousness, which ultimately relates back to potential legal consequences and, yeah, loss of liberty down the line. The inability to even consult counsel about the search is part of that vulnerability.
Exactly. What's fascinating is how the court, faced with these really different situations, a felony trial, a misdemeanor with a tricky sentence, police questioning, an unconscious driver consistently acts to shore up fundamental fairness and protect individual rights, especially when liberty is on the line or when the ability to even exercise those rights is compromised.
So the specific facts drive different legal questions? Sure. But the holdings seem to keep pointing back to protecting the individual within the legal process.
Precisely. The holdings are distinct, establishing the right in felonies, extending it to suspended sentences, requiring warnings before interrogation, permitting searches under specific exigent circumstances, but they all reinforce the importance of procedural safeguards and, often implicitly or explicitly, the role of counsel or the knowledge of the right to counsel, especially when liberty hangs in the balance.
It really hammers home that the right to counsel, established so powerfully in Gideon, isn't just some static rule stuck in 1963. It's a living principle. The court has actively interpreted it, applied it across these different contexts, showing this commitment to making the justice system fair, protecting liberty at these various critical points.
Absolutely. When you look at them together, these cases paint a picture of a court trying to ensure individuals aren't left defenseless against the power of the state, whether that's in the courtroom, facing a potential jail term, or even in the interrogation room. The common thread in the holdings across these diverse cases really does point back to that core Gideon principle, the fundamental value of legal counsel when liberty is truly at stake.
So the key takeaway here seems to be that the Gideon right to counsel is dynamic. It's been consistently interpreted and applied by the Supreme Court in response to all sorts of different legal challenges, but always driven by that fundamental goal, ensuring a fair process when individual liberty is on the line.
Couldn't have said it better myself. And, it prompts us to think, how might future changes, maybe technological advancements or new law enforcement practices, create new scenarios that will further test and shape how this fundamental right to counsel is applied? What might the next Gideon-like challenge look like?
That's a powerful thought to leave our listeners with. We definitely encourage everyone to explore the full opinions of these landmark cases, maybe dig into some related legal resources. It really gives you a deeper understanding of this absolutely essential cornerstone of American justice.
It's a right that's clearly still evolving, still shaping our legal system and our whole understanding of what a truly fair trial means.